Buenos and Hafaday, the Committee on Health and Veterans Affairs is now called to order. The time is 9 o'clock in the morning, and today is Friday, January 16th, 2026. Thank you all for joining us, whether you're here in person or tuning in online. This morning, we're holding both a confirmation and a public hearing on the following items. First, the Governor's appointment of Dr. Annie Bordallo to serve as the physician representative of the Guam Board of Medical Examiners. As well, we will be hearing Bill 219-38 COR, introduced by Senator Shelly Calvo. It is an act to amend subsection K of subsection 82A201 of Article 2 to add a new subsection 82A402, subsection 82A403, and subsection 82A404 to Article 4, and to amend subsection 82A501 of Article 5, all of Chapter 82A, Title 10 Guam Code Annotated, relative to expanding petitioning authority for assisted outpatient treatment under the Baby ALEXYA Law, and to cite this act as the Baby ALEXYA Law Reform Act of 2025. Notice of today's hearing was provided to senators, stakeholders, and the media in full compliance of the Open Government Law. Notice was also posted on the Guam Legislature website and the public notice portal. All materials were uploaded to the committee drive and are available in print upon request. A recording of today's hearing will also be accessible on the Guam Legislature Media YouTube's channel. Before we proceed, I want to recognize the committee members that are present. We have Senator Shelly Calvo, Senator Sean Gumatautau. In addition, we also have Senator Tello Taidagui and Senator Therese Terlahi. For today's hearing, the rules are simple. It's the same. Each senator has 5 minutes to ask questions. Members of the public are asked to approach the table and speak closely into the microphone and state your name as well as who you are representing. We will begin with the Governor's appointment of Dr. Annie Bordallo to serve on the Guam Board of Medical Examiners. If there's anyone here to testify on her behalf, you are asked to please come to the table. And if not, Dr. Bordallo, you may provide your testimony on your appointment. And good morning.
Good morning, everybody, senators. I'm here presenting myself to serve on the medical board. As you all know, I've been a member of this community for a long time, the healthcare community, and I'm happy to, in my retirement, somehow find small ways to continue to serve our community.
Thank you. We will now open up for questions from my colleagues. We will begin with Senator Gumatautau.
Yes, thank you, Madam Chair, and thank you, Doc, for being with us this morning. And I don't have any questions. I know that while you are retired, but at this important time, even in 2026, just having, not to be too facetious, but you're having your brains in the room, your experience to be able to support the entire field is desperately needed, and I think that I'm excited that you're going to jump back in this, and again, I support your nomination from the Governor of Guam. So thank you, Madam Chair, for that, and thank you, Doc, for stepping forward.
Thank you, Senator Gumatautau. I guess I do have a question, and it is regarding, I think we've all seen a lot of the media reports regarding the Guam Board of Medical Examiners and the timely or untimely resolution of a lot of the complaints that have been filed. So if confirmed to sit on the GBME, how will you move that process forward, or what do you see as some of the obstacles?
Well, I think, first of all, is filling the board. So I think having quorums, having the availability of more members kind of spreads the load out a little bit more. In terms of the timeliness, it's always like everybody else about resources, and having the proper resources to be able to do the types of investigations that have to be done. I served on the medical board as the medical director, and sometimes we actually need outside expertise. These are really highly charged issues, and sometimes we need attorneys, we need other types of expertise, and trying to get the funding the way the organization is, I think can be improved. And I think certainly Dr. Berg has worked with many of you to try to get legislation to somehow make that process a little bit easier. But I think that's, like most of our issues here, the system is really contributes a lot to the delays. It's not the people serving on the board, it's just access to these resources sometimes is a little bit more limited than we would like.
Other, I guess, issues that I've heard about are potential, I guess, conflicts of interest. And so how would you address and mitigate these potential conflicts of interest among board members when evaluating complaints or disciplinary matters to ensure impartial decision-making?
Well, again, I think that's why we try to recruit off-island specialists. Again, balancing that with practicing in our community is a lot different than practicing in Los Angeles. So sometimes it's really weighing those kinds of things. Conflict of interest lives in our community because we're all related somehow. We work in a small community. We all know each other. And again, I think, you know, obviously, some of these conflicts is there's fear. There's fear in talking about what's really going on in our healthcare system. We live in a environment of trying to find blame and holding people responsible for bad outcomes, when the reality of where we live is our healthcare system is, you know, subject to, sometimes we have bad outcomes no matter how well we perform. And I think just generally every week we're part of an American system, and culturally that system, we have to find blame, and that just isn't very helpful. It's not helpful for the patients, it's not helpful for the physicians. I think because people just want to know. They just want to know what happened. They don't want to, they're not necessarily trying to get payback. They're not necessarily trying to, but the system doesn't allow us to have that kind of open communication, because there's always this overlying thing that if you get blamed, you're going to lose your license, you're going to lose, you know, your practice, your resources, and there's nothing emotionally that can make up for the loss of a child or a loved one. And so those are competing things that really, we need to have a better system, and we don't have a better system. And until people are willing to come up with a better system, it's going to be like that for a long time. And I don't know what the answers are, but I do know that generally everybody is trying to do the best they can in a system that doesn't have enough resources. And again, we work in the medical field, so, you know, the guy who paints your house, who paints it the wrong color, well, big deal. But we live in an environment that when we make mistakes, the consequences can be quite severe, but it doesn't mean we're more perfect, or the more careful we are, that will never happen. It happens because we're all human beings working and we're all imperfect, and our system is, you know, even below imperfect maybe sometimes.
Well, thank you for that, Dr. Bordallo, and I know that if you are confirmed, I hope to have this open dialogue and conversation on how to fix the system. Senator Tydegui?
Thank you, Madam Chair. Good morning to my colleagues, and good morning, Annie. It's good to see you.
Nice to see you too, Tom.
Annie, is this the first time you'll be sitting on the board of medical examiners?
I served on the board when I was the medical director at the hospital. The medical director serves as a representative of the hospital on the board.
Would that be a voting member?
Yes.
It's a voting member position when you were serving before. Okay.
Yes.
Now, the position that you're taking for board medical examiners is for the physician's part, right? And has nothing to do, you're retired right now?
Yes.
Okay, so there's nothing in the law that says they have to be an active physician, you know?
I have to be actively licensed, so I still maintain my medical license, and I still have privileges at the hospital, so I can still take care of patients.
So you're still active?
If I choose to, yes.
Okay, and you're going to maintain that license?
Yes.
Okay. So is there, so my question to you, because we've gone through a lot of public hearings together, and I think a couple round tables to discuss, you know, the situation with the Board of Medical Examination, Board of Examiners, to discuss the elephant in the room, basically, and that is how many of these complaints that were sent that were never prosecuted, there was no conviction made. You know, that's quite a bit. I mean, from what I hear, there was close to 80 so far that still nothing has come about. How do you attribute that, since you've been on the board already once? How do you attribute that type of outcome, you know, statistics to almost zero? And how would you ensure fairness and transparency in disciplinary proceedings, too, to move forward? So it's kind of a big, round question.
Well, I think, again, the perception, you know, public perception of the medical healthcare system here doesn't necessarily align with the actual job of the medical board. So when you talk about prosecution and disciplinary action, let me just share a statistic. I'm an OBGYN, so about 70%, I trained in New Jersey, so in the East Coast, the litigation rate is quite high. So I think 75% of OBGYN residents will be sued at least once before they finish their residency. And I trained in the 90s, right? I came out here in 93, so late 80s, early 90s. When I came here, I had 7 or 8 lawsuits. So the perception out there in the public is, well, how can you approve a doctor with a license? She has 7 lawsuits. I didn't lose any of those lawsuits. I was never found responsible. They all got dismissed. In fact, the last one got dismissed 20 years later. I mean, I was going back sometimes for depositions or whatever. So I think back to my previous comments of people want somebody to blame. If I asked you, senators, I'm sorry, I was going to say ladies, but you senators, how many complaints you get in your inbox a day? I mean, people complain about a lot of things. I think there are sort of alleys or lanes, so you can go through malpractice or arbitration. I think the medical board, our job is really to try to get to license people and to make sure qualified people come to be licensed. I think people can submit complaints to the board in terms of violating the Medical Act, Practice Act, but I think individual cases, there's a lot more investigation. The average malpractice case takes 7 years to get through the courts, and that's with a whole system of attorneys, expert witnesses, judges, the whole thing. And you think that the medical board with 4 or 5 actively practicing physicians trying to review these cases, and it takes time because half of the cases we have a conflict, so half of the people can't participate. Half of those specialties were not, so it's hard for me to make determinations on an orthopedic case because I'm not an orthopedic surgeon. And when we only have one, I can't ask him to give me an opinion about his case. So I think there's a lot of contributing factors. It's not just, hey, there's 80 cases. Are you telling me not out of those 80, there wasn't one mistake that we should have? There are plenty of mistakes, but much like the 7 cases that I came out with, it's more complicated than you make a mistake, you shouldn't be practicing medicine. If we didn't allow, if we took people off the rolls because they've had a bad case, geez, we wouldn't have any doctors. I mean, we have bad cases. That's part of the job we do. We grieve just as much as the next person, but that's different than somebody who's repeatedly or doesn't know what they're doing. And so I think making those determinations in a public setting, in the newspaper, or the one side of the story, and that's back to my point about we can't tell our side of the story. When I see an article in the paper that somebody's complaining, I can't go to the paper and say, hey, here's my side, because that's a violation. So a lot of times the public only gets one side of the story. They don't, and the system works against us presenting our side because we're subject to disciplinary action, court cases. So that's not a system that's gonna be very acceptable, I think, to most of us, to almost all of us.
Well, Annie, it's flawed. And what are you going to do as a board member to actually improve the process and to actually, find a mechanism that's going to actually work to be able to cover his, hers, and the truth scenario to come out, to be able to address those that are legitimate issues of malpractice? And what is your solution?
Well, I'm not sure that that's the board's function, quite frankly. I think that's the peer review function. If I'm an OBGYN and I have a bad case or a bad outcome, it's the job of the group of OBGYNs who are tasked to do peer review in the clinic, or in the hospital where I have privileges or where that case occurred. I think when it rises to the repetitive nature, then I think that's where the board should come in. But again, the mandate and these communication issues of if you're reviewing a case, it should be reported to the board. So we're aware of what's going on, but the individual complaint itself, I think there are other mechanisms that should be, that other people, that they have to go through first because they're set up for that. And I think maybe, like you said, the system needs to be improved, and certainly, I've lived in this system for 30 years, so there's plenty of improvement, there's plenty of ideas, but we're mandated by a very, how many paragraphs in the articles of the legislature of the law, and so that is it's restrictive in that sense. And again, like everybody else, you hear it all the time. You give us resources, we can come up with something more acceptable, but the reality of you don't do anything about these bad doctors, I'll just tell you, out of the 250 or so doctors that practice here, there may be one bad doctor. There aren't doctors that shouldn't be practicing. There are really, it's a rare occurrence, and that's my experience in the 30 years I've been practicing here. That's a very small. Now, cases and complaints, bad outcomes, well, in my career, I've probably seen 10,000 people. So how many is bad outcomes is too many, that I shouldn't see the other 9,000 and something people. And that's what gets put out in the public. Well, you had this poor kid that died, so you shouldn't be a pediatrician for the other 10,000 kids that needed your care and you got good care. So again, I think the public's perception, and it's back to that communication that we have to have a better way. And I don't think the tort, malpractice, I don't think that's the way. That's been around for many years everywhere in the States, and that hasn't worked there either. So I don't know but it's a bigger thing than the medical board. I think we're trying to make sure that we don't allow bad physicians to come practice because they've had multiple issues other places, and we're trying to keep an eye on all the physician practices to make sure that there's not an outlier that's consistently hurting our community. That's what I think our role is.
Thank you, Annie, for that. And you know, I'm hearing that it's good to hear that, you know, there is an issue with the way it's formulated right now as far as, you know, the process. And I'm hearing a snippet from you that it needs to be changed. I'm wishing it was something larger than just giving me a snippet, because you know there is an issue on medical malpractice here. I'm not going to get into it because it's a huge discussion. And you're right, the board has to look at physicians coming into this island, you know, ensuring that they're safe physicians, that we can trust them to do their job, and try not to make mistakes. But you know, everybody makes mistakes. We understand that. You know, that's the way of life, you know, it's a norm. Everyone makes mistakes. But when you get someone who's doing this repetitively, or that they don't fess up to their mistakes, think they did nothing wrong, then that's an issue, because that's only going to generate another mistake down the line. So I'm hoping that your position on this board is going to keep a keen eye out for those particular physicians. Now, my last question is, I have a bill that I put out. It's the foreign physicians coming into Guam. Of course, that's going to be under your belt to look at. And I know that some states, I don't know if New Jersey, I think New Jersey may have legislation that allows for foreign doctors to come and practice into that state. But the bill that I have introduced, along with CNMI, actually has the same legislation that they introduced and passed, a little bit different. They have the Board of Medical Examiners coming in to revamp a rules and regulations somewhat. For me, I think that having the board do that, you're asking the fox to take care of the hen house kind of scenario, because you're looking at just allowing this to happen when so many people have said that the Board of Medical Examiners, they are it's not picky, but they don't want that many here because they're going to lose clientele for themselves. And this is, you know, this is sad to hear someone say something like that, and I'd like to move that, you know, bad cloud away from the Board of Medical Examiners. No. They are put in place to ensure the safety and well-being of our people, and that this medical doctor coming in will take care of our people so we don't have to go off island, you know, and seek help. So have you had an opportunity to read my bill, the foreign medical doctors?
No,
okay,
I haven't.
Well, it's on the legislative website. You know, I'll be happy to share it with you, and even talk more about it. If you have any comments that you want to make, or the oversight chair has a public hearing on the bill coming up, so we're definitely going to be reaching out to you as well. I have no doubt that you'll be sitting on this board, and I just wish you the very best, Annie. We've talked about medical malpractice, we've talked about other things, and of course we have a personal friendship too as well, that you're going to do what's in the best interest of our people, because the last thing we leave this world is to know, the best thing feeling to know is that we left our island in good hands. And that means it comes from your hands first to do that. So I wish you the very best, and of course, my office is always open. If you have any questions, or you can always talk to me. I think we have each other's number, so I wish you the very best, and thank you for a little bit coming out of retirement, to doing this for us. But I will be watching very carefully. Okay. So
Thank you.
Thank you.
Thank
you
you.
so much, and I might have to excuse myself later on, so I apologize. I have another meeting to attend. Thank you. Thank you, Madam Chair.
Thank you, Senator Tidegway. Before we continue with questions from my colleagues, we do have Jane Flores, who's here to provide testimony. Jane?
Thank you, Senator. Hafa Senator Salas, Matanane, and committee members. I'm Jane Flores, Director of the Bureau of Women's Affairs, and I would like to say that the Bureau of Women's Affairs strongly supports the appointment of Dr. Annie Bordallo as a member or physician representative on the Guam Board of Medical Examiners. Dr. Bordallo served the people of Guam as an obstetrician gynecologist for more than 2 decades before retiring in March of last year. Her clinic, Sagwa Manyagu, Guam's first birthing center and the first women-owned, women-managed, and women-staffed clinic on the island, opened its doors in 2000. For 24 years, Dr. Bordallo and her colleagues and staff provided thousands of women with a setting in which they could experience the birth of their child in a safe and welcoming environment. As a strong advocate for access to women's reproductive health care, Dr. Bordallo will play an essential role on the GBME. Her expertise can help us deal with the shortage of OBGYNs that the island is experiencing right now, a shortage that's also an issue over on the mainland. As a physician and a daughter of Guam, she can also help to meaningfully address our high maternal and infant mortality rates, as well as the alarming rate of sexually transmitted diseases among the island's youth in culturally relevant ways. I have every confidence that she will be selecting doctors that will help us to deal with these problems. I can think of no better person to advocate for solutions to our problems from a medical perspective than Dr. Bordallo. Her extensive knowledge and experience, including having served as medical director of GMH for several years, will be invaluable to the GBME as it tackles our island's many healthcare issues. Senators, please appoint Dr. Bordallo to the Guam Board of Medical Examiners. It will be one of the best decisions that you make in the 38th Guam Legislature. Sijus Masi for the opportunity to testify in support of her appointment.
Thank you. Senator Calvo?
Thank you, Madam Chair. Have a day, buenas everyone. Thank you for being here. And Dr. Annie Bordallo, I just want to say thank you so much for stepping up to the plate and accepting the nomination. Being a board member is really not an easy job, and I speak in general for all board positions. You got to love your island to be able to dedicate a lot of time to service the community. Dr. Bordallo, I really don't have a lot of questions, just very few. And I'd like to say that your medical expertise and your lengthy experience here in Guam and as a daughter of Guam speak so much of your capability to be a board member. And I truly look forward to it. My first question for you is, as a licensed physician, how do you see your role in upholding professional standards and ensuring accountability among Guam's medical practitioners?
Well, I see that we take our job seriously, and I think, again, there's a big shortage of physicians. The healthcare system over the 30 years I've practiced has changed a lot. And I really, trying to support physicians is important. I think the healthcare system here, people have to be healthier. I think everybody has a role to play. And I think, fortunately, the education of most patients of taking your healthcare more seriously puts a lot less pressure on heroic savings at the hospital. I think people don't realize, they think they go to the hospital when they're sick and that we can save everybody, but a lot of it starts much earlier than that, and I think the younger generation finally is taking that to heart. I see the younger generations of kids be a lot more healthy than I think I was or we were at that same age. And I think that education is really making a big difference. And I try to stress that to our patients, that you have some responsibility too. And it's okay that you underperform, because I'm a little underperforming in my own health journey, but then the expectation that somebody's going to save me from that, I have to sort of own a little bit of it too. So I think in that sense, I don't know if that answers your question. I think we take our job seriously. I think physicians try to be as careful as they can be, but there's lots of different factors that kind of contribute towards where the outcome goes. And there's so much in healthcare and medicine that we don't know. I think that's, again, back to that communication issue about, we make it seem, because technology is great, because we're learning so much more, the internet is around, that we know everything, and the reality is there's probably a bigger section of things we don't know that that even we as human beings would like to admit.
Thank you. Dr. Annie, I'm glad that you raised that issue. It's true that our community these days are more active, proactive in taking good care of themselves. On that note, what do you think are emerging healthcare issues that you believe should be prioritized by the board? And how would you contribute to addressing them through policy and engagement?
Well, I think, again, it's movement is the medicine, right? If everybody would move a little bit more. So I think in terms of policy making, I think we have to have more access to playgrounds and gyms and sports facilities and dance and art, so that kids can get out. And I think in terms of the communities that are underserved, how do we get them access if they don't have a ride, or they don't have parents who will take them there, or they don't have, I think the community-oriented, when I was a kid, I just had this conversation with one of my family members. My parents didn't have to take me to practice. They didn't have, because I could walk, because it was at the community center, it was at the mayor's office. We all lived within walking distance. And in those days, I think we always thought it was far, but it was like really literally like a quarter of a mile. But those of you who are parents of young kids, you wouldn't even let your kid walk out to like the front yard. So I think some of those, bringing those community things back to, or schools, the after-school programs that involve more healthy activities for people who really don't have access to, their parents are working, transportation. I mean, things like that, I think, make a big difference.
Dr. Annie, I believe that you're going to be part of this board. So on that note, on my last question, I just want to ask if there are any procedural changes or updates that you believe could strengthen the board's efficiency and transparency.
Well, I think, I don't know. I haven't been on the board for a couple of years now, but as my recollection was really, again, having more control over, the budget. I mean, I think we collect licensing fees, and somehow we're hooked to public health, or and I don't know if that's still current, but I think having a little bit more independence so that, I think this is a very common theme, kind of being a part of a line agency versus I worked at the hospital as a semi-autonomous age. And so there are different things in terms of being able, like I said, to spend the resources in a timely fashion to bring expertise in and that we need. I think that is one of the things that they've been talking about for quite a while.
Thank you so much. So on that note, Dr. Annie, that was my last question. I truly thank you again for stepping up to the plate, and I look forward to your confirmation.
Thank you very much.
Masi, Madam Chair.
Thank you, Senator Calvo. Senator Terlai?
Thank you, Madam Chair. Thank you, Dr. Bordallo, for being willing to serve in this capacity during your retirement, as you claim. But I know you've served in this before, so I know that you know what it's going to be like for you, the time commitment. So the board, from my understanding, actively, they delegate the cases out, the complaints among the members, and they each review a batch, and then they report back to the boards. But I'm sure you haven't missed in the news that there are some complaints that have actually been lingering. Now, they've made some big progress and cleared many, but there are still some that have been there for years. So we really need a solution to that because I don't think that's satisfactory, and I don't think that other jurisdictions would allow that to happen either. When you suggested that, so the board is, their duties are you know, they can review many things, unlawful practice, you know, whether you're not getting back to your patients quick enough, lots of administrative kind of violations by doctors. And of course, they are also, according to our statute, supposed to review negligence. And they're supposed to discipline for negligence. And you're suggesting that the negligence, when they need specialists to help in determining whether there was negligence, that these should be determined by a peer review. Are there in place peer reviews for all doctors on Guam?
No, I think the board serves as I should say, the review for the outpatient clinics, because they aren't necessarily a member of a group. But again, those are the kinds of structural reorganizations that will help. I think it's asking a lot of the board to oversee every single case, because again, there are implications of that. I think the hospital has a peer review committee and that's fairly robust, and each department, so the surgical department, the OBGYN department, they review any complaints and they have criteria of what falls out of the standard, and that's how they choose what cases to review. But yes, anybody can come to the board and say, hey, I want that case reviewed. And again, if we had a lot of the state boards are much larger, right, because they have a bigger, so their structure is designed to do that. I don't know that we do review them, but it just takes time. I mean, if I'm reviewing, and the cases are handed out based not necessarily on specialty, but we're limited anyway because we don't have that many specialties of the physicians on the board.
But would you agree that it's really just the negligence cases that require sometimes a specialist to review those? Otherwise, the rest of the violations that are listed here,
and not all negligence
boards should be able to review.
No, of course, of course.
And boards can review some negligence cases, as you say, and there are no peer review for many of the doctors on Guam. So this is the only kind of review that they're going to get is through this licensing board. And is this the case in other jurisdictions? Are you aware? Or is there a peer review for private clinics in other jurisdictions? I guess I'm just asking, is that really realistic to say that the board can't really review these and we need a peer review board to review these?
No, I'm not saying that we can't review them. I think we do review them, but it takes time because if, again, you have 4 or 5 people on the board and they're all practicing, right? I mean, so, and to do a good job of reviewing a case, it's the volume. So again, I don't know. I don't recall really any administrative type of complaints as, you know, that many.
Well, there was the complaint of sexual assault. There was, okay, remember those types of complaints? Sure. I don't think we need specialists to determine.
No, of course,
those,
and those are reviewed.
All right, so there are cases where the board has sought specialists, and I actually haven't seen complaints that the board members themselves aren't getting back with their reviews. It's always that when there's a recommendation that there's some additional review, then those cases kind of get stuck in a procurement process or an AG review process or a lack of AG review or a lack of a specialist that they've been able to procure. And so recently, the HPLO administrator said they changed the process on her also. Instead of being able to procure these specialists through a purchase order, she's now required to put out an RFP, you wait for a response, and then you negotiate with them. And that for her, the result was that it really increased the cost. So when we get back to the cost, this was originally the problem, but I don't believe that that is the problem today, or it should not be. First of all, public health is maybe part of the problem because the HPLO's request for budget, I don't think, has been honored by public health necessarily. And so that means that what the medical examiner's board needs, the medical examiner's board has to obtain through fees. And those are fees set by the medical examiner's board, the licensing fees. And so that's why each of these boards have been tasked to implement fees. Some have not yet, so they're not paying their fair share, but you're supposed to implement fees that are able to, that you need to manage the, you know, overseeing that you need to do. So if it's looking like, you know, we need more fees in order to hire more specialists to review more cases, then that might be something the board has to consider. I know nobody wants to increase fees, but those are the kind of the choices we're at. It's either the AG covers it, and they used to cover certain, they used to cover the board meetings, right? But when you needed an investigator or you needed a public hearing officer, they didn't want conflict, so they wanted to do it where you hire your own. So that's what the boards have been doing. And they've been able to hire, despite the challenges, they've been able to hire. And that's what they're using is the fees and a little bit of the budget that public health secures for them. But I guess, so that's what I'm going to ask you. If we need other people, and we need to hire them to help us in doing this work, it might need an increase in licensing fees. And are you willing to review that whole cycle of chicken and egg, I guess? It's like if we are going to really do a thorough review with specialists, then we're going to need to have a little bit more money to do that.
You know, I mean, I think the budget is, again, in my experience a few years ago, and I don't know what has changed between that time and now, was that it was opaque. My understanding was that we had enough money in terms of fees. We just, again, had to go through processes that are kind of unreasonable. I mean, to go through the central office and all around, however these things work, that was the issue, as opposed to being in control of our own
The money.
budget and money
All right,
and
well-
saying, okay, pay the guy and here's the check. I mean,
That should be better now, I think, because I think they've resolved a lot of that, and the current administrator is able to go out and do these types. Some of the issue was they changed the requirements, right? They said, no, now you can't use purchase order, you have to use an RFP. That's just a lengthy process, and that is a more costly process. So you could push back a little, and we could see whether that's really required, and perhaps we could all take a look at that as well and see if there's a better way to procure that. And if there is, we'll take any recommendation. Otherwise, yeah, I just say, regardless of that, right, we need answers and we need to just resolve the cases. I think that's really the bottom line, that that's the only way that the public is going to have some faith that the licensing board is able to do what it is tasked to do, and especially when it is the only one tasked to do that on Guam right now. So, but I agree, the peer review system should, I think they're required to report any peer reviews that the hospitals do are supposed to be reported to the board. So I don't think that's really a problem, but if there's another way to set up a peer review to assist you instead of hiring specialists, I don't think that's gonna fly, but if that's possible, you know, maybe you can make a recommendation to do that. But my other question is, so Ms. Flores, the Bureau of Women's Affairs suggests that you being on the board is going to help. By the way, I know she says you're going to help with the shortage of OBGYNs that the island faces, the high maternal and infant mortality rates, and the alarming rate of sexually transmitted diseases. And do you see your role on the board as helping us to come up with policy in those areas?
well, I think, again, physician recruitment, expanding, as Senator Tydegui said, expanding eligibility to bring more physicians in. I mean, those of us who travel off island for medical care, if we travel to the Philippines or to Asia, we get our medical care there. Why can't those doctors come here? And those are big, because we're not an independent country. If we were, we would have solved those issues a long time ago. But we are subject to immigration laws, we are subject to licensing that comes from the US. These are not local, it's not under our purview to expand that. Now, again, there's physician shortages everywhere, so I think the US is now expanding those because they need to, there's like 50,000 doctors in Mexico that can start practicing with similar training, and it's just back to how do you filter out the good ones versus not, or how do you verify their schooling? Is it equivalent to our training? If it's equivalent, then there should be a pathway for them to have licenses here. But those are the structural obstacles, but that can be solved, and then we'll have a whole array of many physicians available to be hired. But that's a US problem as well, and they're, like Senator Tydegui said, and there's so many states that are now trying to get these licensing regulations changed so that they can bring these physicians in. So in that sense, I think, yes, we can try to recruit from that standpoint.
All right, yeah, so Senator Tydegui had a bill, and I know that the board had also, independent of that, been discussing, and now I think they're discussing it together. But I think, yeah, the sooner that can be moved, the better. But just, I guess, for those who are listening, how do you see the cases moving forward? Let's say you do have control of your money and you have hired specialists. Last we heard, they were waiting for the AG's, I don't know, approval of the contracts maybe, because RFPs have to go through him now. But how would you help, I guess, the public's perception of the board not moving on some cases for several years?
Well, I wasn't involved in those cases, so I can't speak to those specific cases. The only thing I can say is that I'll just be one more person, you know, so that to take on, I'm another person that will expand the ability to review those cases. I mean, we can resolve cases that we can resolve quickly. Other cases, as you said, if we can't change the process that requires us to get an attorney general's approval that isn't approving anything, I'm not really sure how that's back on the board. And if the public doesn't understand how these processes interfere with that, then I'm not sure I can mitigate that. But certainly I'll be one more person, so there'll be more of us to review cases, and I'll certainly take on, you know, those cases and try to get as many of them resolved as we can. But again, I think you know, is it the timeliness, or is it the fact that they're not satisfied with the decisions
No,
that
it's
are
the
made?
lack of a decision. It's really that, and that's why it's kind of not acceptable, I don't think, for anyone. And I'm asking, I guess, if you would commit to being new again on the board, just a fresh look at those cases that have been there for several years, and if they can be handled in any different way, that you push that
Sure.
you actively look for that, because I just don't want everyone to think that that is acceptable.
Okay, I'll be the code case.
Yes.
I'll take on
Thank
those
you.
code cases and try to get them
Thank you,
cleared
Senator
as best
Terlahi.
as I can.
I appreciate that. Thank you, Dr. Bordallo. Thank you again for your service.
And just for the public that's watching, we do have the public hearing scheduled for Bill 206. That is Senator Tello Taitagui's bill. It is scheduled for February 11th. I did have one just follow-up question, and it's something that I've been hearing about. I just met with the Federation of State Medical Boards, and as well as Dr. Nathaniel Berg. And one of the things that I brought up when we discussed was the difference between whether you work at GMH or you work at a private clinic, and the requirements for reporting disciplined doctors to the National Practitioners Data Bank. And one of the things that was told to me was that if you are practicing at GMH and you are disciplined, you know, they're covered under the Government Claims Act. And so early on, I had FOIA'd for some of the settlement cases, and I received quite a few, but they were never reported to the National Practitioners Data Bank, and they weren't forwarded to the Guam Board of Medical Examiners. Having had experience with the GBME, is that how the process works, or do you believe that if you work at GMH and you have settlements that have been litigated, resolved, should they be reported to the GBME and then reported to the National Practitioners Data Bank, so the public and the community here on Guam know if a doctor has been disciplined despite where they work?
Yes, I believe that all disciplinary action that has been resolved and resulted in a disciplinary action is reportable to not only the medical board, but to the National Data Bank. I think, like most legal things, there's a lot of different interpretations of that. So when you're at when the Government Claims Act, if there's a settlement, the settlement may not be on behalf of the physician, but maybe be on behalf of the hospital. And so that's not reportable under the physician's name. So I think that may be the discernment. But if the settlement is made on behalf of the physician, that's a reportable event, and it should be reported to both the Guam Medical Board and to the National Data Bank. That's the law. It's not an optional kind of thing. So I think, again, back to resources and representation, some of those issues are not intuitive and not so straightforward. And we get subject to litigation as well. So I think back to having the resource of, do we have attorneys that understand healthcare law? Do we have that we can call on? It's not as, this is a complex kind of thing. It's not as easy or as straightforward. So this is a discussion I've had multiple times with Dr. Berg. It's like, well, what am I supposed to report? Just as you said, once it goes to peer review, is that already a reportable thing, or am I supposed to wait until the thing is resolved, and then only if there's a disciplinary action is it reportable? So I think there's a lot of these kinds of situations that again lead to this type of you know, was it reported, was it not? And again, it's just back to communication and the process. You know, is it checked off, hey, as it goes down the list, it's somebody whose responsibility is it to make sure it gets reported to the places it's supposed to be reported to.
Thank you, and thank you for stepping up and accepting this appointment, and we look forward to working expeditiously to get this on the next session agenda. So thank you so much for accepting the nomination.
Thank you very much.
We will now turn to Bill 219. And if you are here to testify, please take a seat at the table. And before we begin and accept testimony, we will hear opening remarks from the bill's author, Senator Shelly Calvo. Senator.
Sidusmase, Madam Chair. Thank you for hearing this, for placing this bill on the agenda. And Sidusmase to everyone, and thank you, good morning, as well as my colleagues that are here today, and to everyone in the panel. Thank you for the opportunity to offer opening remarks on Bill number 219-38 COR. When we gather to discuss mental health policy, we are not simply debating statutory language. We are confronting how our community responds when someone is unwell, when families are struggling, and when warning signs appear long before an emergency call is ever made. These conversations are often difficult, but they are necessary because the cost of getting this wrong is measured not in dollars or caseloads, but in human lives and long-term harm. The Baby ALEXYA law was enacted nearly a decade ago in response to a tragedy that deeply affected Guam. It was a recognition that untreated serious mental illness, when left unaddressed, can have devastating consequences. That law sought to create a pathway for assisted outpatient treatment that was careful, structured, and respectful of civil liberties, while still allowing intervention when it was truly necessary. There's a little struggle happening here. That framework remains important. It is grounded in clinical judgment. It requires judicial oversight, and it preserves due process protections that are essential in any system involving court-ordered care. Bill 219-38 does not challenge those principles. Instead, it asks whether our current procedures fully honor the preventive purpose that animated the Baby ALEXYA law in the first place. Under current statute, the authority to initiate an assisted outpatient treatment petition rests primarily with the Guam Behavioral Health and Wellness Center, acting in conjunction with a treating physician. That model ensures medical oversight, but it also means that the system often becomes activated only after an individual has reached a point of acute crisis, after hospitalization, after arrest, or after emergency detention. So for many families and frontline professionals, this reality is painfully familiar. They see the warning signs early: untreated symptoms, missed care, escalating behaviors, and cycles of instability. They attempt to intervene informally. They seek help, and yet, too often, there is no clear, lawful mechanism to elevate these concerns into a structured, court-supervised process until the situation has already deteriorated. Bill 219-38 asks whether there are moments earlier in that trajectory, moments recognized first by family members, caregivers, hospital administrators, when credible concerns responsibly be brought forward the court before a crisis becomes inevitable. This bill does not propose that anyone act alone. It does not allow treatment to be ordered without medical involvement. It does not eliminate judicial review, and it does not expand the criteria for assisted outpatient treatment. In fact, it strengthens procedural clarity by requiring clinical affirmations, notice to all relevant parties, the right to counsel, and prompt judicial hearings before any order may be issued. The intent of expanding petitioning authority is not to widen the net indiscriminately. It is to acknowledge that the information about risk and deterioration often exists outside of a single agency, and that our legal framework should allow that information to reach the court in a responsible, timely, and safeguarded manner. At its core, this bill reflects a belief that our mental health system should be designed to intervene before harm occurs, not only after. It is about shifting from a reactive posture to a proactive one, while remaining anchored in compassion, medical expertise, and respect for individual rights. It appreciates the committee for allowing this important discussion to take place today, and I look forward to hearing from those who will share their expertise, experiences, concerns, and insights as we consider how best to strengthen this bill. Sedus Masi, Madam Chair.
Thank you, Senator Calvo. We will now accept public testimony. We will begin with Justice Merriman. Please speak closely into the microphone and again, state your name and title. Thank you.
My name is Catherine Merriman, and I serve as an Associate Justice of the Supreme Court of Guam. Through my career, I've been an advocate for improving care for persons with mental illness. I don't directly deal with litigants in that area anymore, but it's a prime concern to me. The judge who is handling the mental health court is Arthur Barcenas. He just returned from a trip, so I'm here on behalf of the judiciary. With me is the administrator of the courts, Danielle Rossetti, the public guardian, Andrew Paris. This bill is very important to the judiciary. The judiciary and the executive branch have been working to implement the sequential intervention model that's been proposed by SAMHSA. And one of the biggest issues that we faced is there are people in the community known to have mental illness, but who are not patients at the Department of Behavioral Health. And right now, the law requires the director of the department to petition the court for outpatient supervision. So although we have some technical corrections we'd like to make and recommend, our primary concern is expanding the definition of petitioner to cover other professionals in the community, or more importantly, family members and friends who want to go before the court and ask for care for their person that they're concerned about. Also, Judge Barcenas has told me there are often times that people go into the criminal justice system and end up in the mental health court that really haven't committed a serious offense. Maybe the family is too stressed and there's been an altercation, or maybe the person is homeless out in the streets. Suddenly they're in the mental health court, and he said it would be much better if they could go into the civil side of the court and be supervised for outpatient care and get out of the criminal justice system. That is part of what step one of the sequential model calls for. And we just are very concerned that it's so restricted now about how the petitions come in that people who should be before the court for this program are not able to do that. Also present, just to answer any questions, is the public guardian who, right now the court has over 100 wards that we care for. But if you have any more technical questions, he's here. He's an attorney, but he's also the public guardian. I could read through my letter, but unless you are satisfied with its being part of the record, I could just stop now and answer any questions you have.
If you, okay. Yeah, if you could read the letter into the record, please.
Yeah, okay.
Good morning and Hafaday, Madam Chair and members of the committee, Danielle Rossetti, Administrator of the Court, and I will read the testimony into the record. Dear Madam Chair and members of the committee, thank you for the opportunity to provide testimony on Bill number 219-38 COR. The judiciary recognizes the seriousness of the issues addressed by this measure and the legislature's intent to strengthen Guam's assisted outpatient treatment framework in a manner that promotes public safety while respecting individual rights. Because AOT proceedings involve compelled medical treatment and court oversight, clear procedures and due process protections are essential. To this end, the judiciary respectfully offers the following section-specific comments and proposed amendments. These comments reflect input gathered from our judicial officers and staff who examined the measure's potential impact on court operations and the individuals we serve. Section 2, Legislative Findings and Intent. In Section 2, the judiciary suggests that the findings and intent expressly affirm principles of least restrictive care and recovery-oriented treatment. Clarifying these guiding principles would help anchor the statute in established mental health standards and provide direction to the court when weighing petitions that involve significant liberty interests. Section 3, Amendment to Section 82A201K, Definition of Petitioner. With respect to the expanded categories of petitioners, the judiciary recommends consideration of additional safeguards. First, when expanding petitioning authority to non-clinical petitioners, the legislature may wish to consider requiring standardized training for such petitioners and establishing an oversight mechanism to monitor petition filings. These measures would promote consistency and reduce the risk of inappropriate or unsupported petitions. The judiciary has provided training for guardians and is willing to assist in training petitioners as to the guardianship law and responsibilities of guardians. The public guardian could assist in the development of a program, deferring to medical professionals on other aspects. Second, under proposed subsection K1, the term resides could benefit from clarification. specifying whether the term refers to a long-term caregiver, a household member, or other defined relationship would reduce ambiguity and help prevent potential misuse. Third, under subsection K6, the judiciary recommends removing the inclusion of peace officers as petitioners. Peace officers are trained primarily in public safety and law enforcement rather than mental health diagnoses. Granting petitioning authority may blur the line between policing and medical decision-making and risks transforming AOT into a quasi-criminal mechanism rather than a medical safeguard. Finally, the inclusion of judges and attorneys as petitioners raises potential conflict of interest concerns, particularly where those individuals may later be involved in adjudicating or representing the subject of the petition. We therefore recommend removing subsections 8, 9, and 10 and replacing them with the following language. A legal officer or attorney may petition only if not involved in adjudicating or defending the subject in the same proceeding. Section 4, new Section 82A 402, petition to the court. In Section 4, the judiciary recommends adding a new subsection to strengthen clinical safeguards when an examination is refused. The proposed additional subsection D reads, if the subject of the petition refuses examination, a second licensed mental health professional must review the petition and affirm the necessity of assisted outpatient treatment before filing. This additional review would provide an important check in cases where direct examination is not possible. Section 5, new Section 82A 403, service. In Section 5, the judiciary recommends adding a new subsection to clarify service requirements and provide respondents with adequate notice. Clear notice timelines are critical to meaningful participation and preparation. Proposed subsection E. Notice shall be served by certified mail or personal delivery at least 72 hours before the hearing. Section 6, new subsection 82A 404, the right to counsel. While subsection 82A 404 establishes a right to counsel, it does not explicitly require the appointment of counsel for indigent respondents. To ensure meaningful representation, the judiciary recommends clarifying that counsel shall be appointed when the respondent is unable to afford representation. Section 7, amendment to subsection 82A 501, hearing and orders. The judiciary recommends amending subsection A to allow additional preparation time. The hearing shall be scheduled no later than 7 days from receipt of the petition. Additionally, subsection C would benefit from clarification regarding, first, the duration of an AOT order, requirements for periodic review, and a process by which respondents may appeal or request modification of an order. Absent these safeguards, ongoing restraints may raise due process concerns. With respect to subsection D, the judiciary recommends clarifying the standard for in absentia proceedings. The proposed amendment, in absentia hearings may proceed only after documented efforts to contact the subject and judicial findings of necessity. Section 8, effective date. The judiciary suggests consideration of a sunset clause requiring legislative review of the Act after 3 years, allowing policymakers to evaluate implementation, outcomes, and unintended consequences. General due process consideration. Finally, the judiciary notes that the bill does not specify the standard of proof applicable at AOT hearings. Leaving this undefined creates uncertainty and may invite constitutional challenge. Involuntary treatment proceedings generally require clear and convincing evidence as articulated by the U.S. Supreme Court in Addington versus Texas, 441 U.S. 418, 1979. Clarifying the applicable standard would strengthen the statute and provide guidance to the court. Sequential intercept model, which Justice Merriman spoke briefly about. Recently, training on SAMHSA's Substance Abuse and Mental Health Services Administration sequential intercept model for intervention for persons with mental illness or disabilities concluded. Many executive and judicial agencies pledged to work towards implementing this model on Guam. This legislation will assist in implementing this plan for Guam. In conclusion, the judiciary appreciates Senator Calvo and other members' efforts to strengthen Guam's assisted outpatient treatment framework. We respectfully offer our assistance with any drafting or clarification that may be needed as the bills move forward. Censor Amenti, Catherine A. Merriman, Associate Justice.
Thank you, Mrs. Rossetti and Justice Merriman. We will begin questions by opening up first to the author, Senator Calvo.
Thank you. I'd like to thank the Judicial Court and Chief Justice Merriman for all these recommendations. That is very imperative and important to tighten this bill. So I truly appreciate your testimony. At the moment, I don't have much question. I prepared some questions with other agencies, but I'm gonna ask our colleague here to move forward for the meantime. I'll probably ask a little bit before my closing remarks.
Sure,
Yeah.
sure.
Thank you, Madam Chair. Thank you again.
Senator Gumatato.
Yes, thank you, Madam Chair, and thank you to my friends from the Judiciary of Guam. It hasn't been that much of a long time that I haven't seen you, but I just had a couple of things, Madam Chair, that I just wanted to kind of point out to the committee. First off, it seemed like it was many moons ago, Madam Chair, in 2019, when the National Council of State Courts came to Guam, held their mapping results website workshop for the judiciary. As Justice Merriman mentioned earlier, she's been a big proponent of trying to kind of bring together stakeholders. And I think when we think about it, that seemed like such a long time ago. In 2019, pandemic happens, here we are talking about the sequential model in the present and the efforts that this bill will do to help strengthen the judiciary's role, but also, not just yours, but also the rest of this community in dealing with justice-involved people with mental and substance abuse disorders. So I'll say kudos. I did listen to your input, and as part of the committee, will work with our chair to ensure that the recommendations that were outlined by the judiciary are in this bill to ensure that it is really strengthened, and I do stand committed to doing that. I only had a couple of questions and I don't know if you can answer it for me, but I'll just go ahead and ask it anyway. And if you can, great. If not, I'm sure that we can, as the committee, can ask of others. But recognizing that Guam Behavioral, they received $500,000 in their assisted outpatient treatment grant funding from SAMHSA. This was for FY 2026. What information, or maybe you can offer up insight if you can, what information is available summarizing Guam's participation in any prior or ongoing review by the federal government regarding the grant program, but including but not limited to participant outcomes such as treatment adherence, psychiatric emergency room visits, hospitalizations, perhaps maybe arrests?
Thank you for that question, Senator. I can say with respect to our partnership that we have with Guam Behavioral Health and Wellness Center relative to the AOT is that we do have, we had 3 of our judges, Judge Barcinas, who presides over the mental health court, attend training, off-island training. We are currently partnering with Guam Behavioral to put on AOT technical assistance training in late February. So we are, which explains the important measure for expanding the definition of who can bring a petition before our courts, because following this sequential intercept model training we did it in 2019, and then we reconvened again. And so we have been working with the technical assistance providers to get us where we need to be, providing training to those in the community. But more importantly, Judge Barcinas and the judiciary are working closely with Guam Behavioral to ensure that what the SAMHSA grant says we are required to do, or what we should be doing for assisted outpatient treatment, is being followed.
Okay, and along those lines, Danielle, with respect to authorizing peace officers to petition for persons to receive assisted outpatient treatment, to what extent has the Mobile Crisis Response Team, which is a community-based intervention program with the Guam Behavioral, helped, maybe you might have heard, how has it helped those peace officers thus far to identify and secure appropriate mental health services for individuals in a timely manner and to ultimately de-escalate potentially devastating outcomes? What have you heard in your role?
So probably it was about 2 years ago now where Guam Behavioral sent a team of individuals to go to crisis intervention training. I was included as part of that. So we do have CIT coordinators that have been trained to provide assistance with respect to responding right out in the community. One of the key things with the mobile crisis unit, which is operable from what we've been told and how it's helped us, in fact, in a few cases that in criminal matters before Judge Barcinas, is such that we train the peace officers, the law enforcement, to how to recognize the symptoms of mental illness when they're responding. And the part of the SIM mapping is that at stage 0, right, there's that who do we contact? And contacting the mobile crisis intervention team, they respond, they know how to interact, and then we go to the next phase rather than the typical take them in, let's arrest them. They become part of the mental health court criminal docket, which really is we're trying to just divert them out of the system, the criminal justice system.
And thank you for that. And I think, Madam Chair, I'm sorry.
If I could just add, Judge Barcinas said that recently, if there's a call to the mental health court probation officers that there's a crisis, they've been able to work closely with the crisis intervention team, and on a few occasions been able to handle the entire situation without having to call the Guam police, which is something we would like happens every time, but we're getting, at least seeing it start now.
No, and exactly, and just to kind of go back, Madam Chair, that as we hear about these things, to keep, there's a lot of humanity in this when we think about the work that is done by all of our public safety officers as they engage in the field. And again, who would have thought to come back to, in this new branch, to be able to help? Justice Merriman, I do stand ready and prepared to help support you and the branch. Any community-based solution, Madam Chair, really to help justice-involved people with mental and substance use disorders, we really should be standing firm in that and trying to do all we can. And I think this bill is just that one step, in my humble opinion. But again, thank you for being with us. And again, we'll take the amendments back to committee. And Madam Chair, I do stand ready to help support that. Thank you again.
Thank you, Senator Gumatato. As well, I don't really have any questions. I think from the testimony that was read by Mrs. Rossetti, it kind of answered a lot of my questions with regards to whether or not there were any safeguards in place. And additionally, I did have some questions for the Guam Behavioral Health and Wellness Center, but they were unable to make it to today's hearing, but they did provide written testimony, which I'll allow Senator Calvo. I also, before I turn it over to her, I wanted to thank her for her hard work on this issue. I know that she has been working with the judiciary of Guam to help update the law. So thank you. It is inspiring to see your work on this, Senator Calvo.
Thank you so much for all your recommendations. And like my colleague said, moving forward, we're going to work to tighten this bill. And I truly, truly appreciate all your input. I know we're all in the same page and recognizing that this is necessary. And I really thank the judiciary and Judge Merriman, of course, Daniel, and everyone here today for the support that you guys have shown and given to this particular bill. And I look forward to working with you guys further. And if there are other questions, and I know where to find you guys.
Senator, if I may just add to the bill's measure, I would be remiss if I didn't note, aside from the AOT training that we will be conducting with Guam Behavioral in late February, we are also going to be following the SIM mapping training that we did, providing CITE training, that's the crisis intervention training, right? We want to be able to expand the training to the community folks so that we know how to respond. So taking the recommendations that we presented into consideration is deeply appreciated, and we hope this measure moves forward swiftly.
Thank you, Ms. Danielle.
Dad, we have been in contact with John Lozama. He was reaching out to us to try and get assistance in making sure peace officers who are under his sort of oversight are properly trained. So we're working with him as well.
Thank you. So aside from this testimony recommendation, the testimony will also take into consideration all the trainings, the technical assistance trainings that are going to, the results of that and updates from that will take it into consideration. Thank you.
Thank you, Senator Calvo, and we look forward to hearing more about the training for the crisis intervention treatment and the assisted outpatient treatment. We will work with. Yeah, do you want to read? I'll let you read it. Well, again, thank you for your testimony, and we appreciate your work on this legislation. And before we close, we'd like to read the testimony. We'll read the testimony from the Guam Behavioral Health and Wellness Center. Senator Calvo, thank you.
Thank you once again. Ladies and gentlemen, have a day once again. And as the committee chair mentioned, we received a testimony from Guam Behavioral Health and Wellness Center, and I'm just gonna read it for the record. So, honorable senators, committee chair, testimony for Bill 219-38, Baby Alexya Law Reform Act of 2025. Buenasan, half a day, Senator Calvo, and committee chair, Senator Sabrina Matanane, Salas Matanane. Guam Behavioral Health and Wellness Center, GBWIC, appreciates the opportunity to comment on Bill 219-38, an act to amend subsection K of subsection 82A201 of Article 2 to add new subsection 2A402, subsection 282A403, and subsection 82A404 to Article 4, and to amend subsection 82A501 of Article 5, all of Chapter 82A, Title 10, Guam Code Annotated, relative to expanding petitioning authority for assisted outpatient treatment, AOT, under the Baby Alexya Law, also known as the Baby Alexya Law Reform Act of 2025. The Substance Abuse and Mental Health Services Administration awarded GBWIC a 4-year AOT grant with a target of serving approximately 20 clients per year. The funding is intended for a small pilot-level caseload designed to test the AOT model on Guam, build internal capacity, and evaluate outcomes. There are concerns that if Chapter 82A is amended to broadly expand petitioner status under subsection 82A201K to many different stakeholders, the law may unintentionally create far more AOT petitions than our program was resourced to handle. Each petition requires a clinical review, a current psychiatric evaluation, coordination with counsel, and ongoing case management and follow-up. With only one AOT team and capped demonstration caseload, the central question becomes who will carry this workload and at what point do we compromise quality and fidelity. For this reason, JBWIC recommends that any expansion of petitioning authority be carefully scaled to our actual grant capacity and implementation phase, or paired with additional resources and staffing. Additionally, while subsection A2A201K appropriately recognizes that adult family members, roommates, licensed mental health professionals, agency directors, hospital administrators, legal officers, peace officers, parole, and probation officers, and a Guam public guardian may identify high-risk individuals. JBWIC is concerned that such a broadened list of individuals who may petition may shift the program away from its original intent as a clinical civil commitment tool. As stated in Chapter 82A, otherwise, the current 72-hour involuntary hold stated in GCA Title 10, Chapter 82, may be a sufficient tool to identify and treat high-risk individuals that meets the intention of the bill. JBWIC also recommends that any expanded petitioning authority in subsection 82A201K remains dependent on a recommendation from a qualified mental health professional so that AOT is used only when it is clinically approved and not for other purposes. We note that the amended subsection 82A501 allows the court to proceed with a continuance-assisted treatment hearing, even if the subject of the petition does not appear, so long as appropriate attempts to elicit the attendance of the subject have failed. JBWIC recommends clarifying that what constitutes appropriate attempts and ensuring this provision is implemented consistently with the existing Patient Bill of Rights and emergency and assisted treatment hearing protection created under the original Baby ALEXYA law in Chapter 82A. In 2019, Treatment Advocacy Center's Policy Director Brian Stetton advised JBWIC that AOT is part of the mental health civil commitment framework and fits most naturally within Chapter 82 rather than a completely separate Chapter 82A. He identified 4 reasons. Chapter 82 is meant to encompass all aspects of mental health law, and AOT fits under the umbrella. Number 2, separating AOT into its own chapter can send the wrong signal that AOT is primarily a law and order measure rather than a tool to help people with mental illness. Keeping inpatient and outpatient commitment together in Chapter 82 reinforces that they are points on the same continuum of care, and placing AOT within Chapter 82 allows Guam to use existing definitions and burdens of proof, avoiding conflicting standards of redundant language. JBWIC hopes that any reform to the Baby ALEXYA law will incorporate technical guidance offered by TAC or TAC, especially feedback received during their scheduled visit on Guam on February 24 to 27, which we actually mentioned earlier on the floor that we will also take into consideration any update or any results or any recommendations from that visit, from the technical assistance visit. This will ensure that AOT is framed first and foremost as a clinical recovery-oriented civil commitment option. We would like to sincerely thank you for the opportunity to provide testimony, and we look forward to continued collaboration in ensuring that all individuals have equitable access to the services that they need. Undangkal na si Dusmase, Director of JBWIC, Ms. Carissa E. Pangilinan.
Thank you. Thank you, Senator Calvo. We will make copies and additionally upload this to our committee drive so that members of the public can read it for themselves. And we certainly appreciate the Guam Behavioral Health and Wellness Center for providing this testimony, as well as the Judiciary of Guam for being present. So the timing, I think, is good, considering the fact that we have the off-island representatives who will be on Guam next month, and hopefully we can get the markup process to go through, and then hopefully get this onto the March session agenda. Senator Calvo, would you like to close?
Thank you, Madam Chair. But before I close, I would like to give Judiciary an opportunity to comment on the last testimony from JIBWIC. But if not, I guess we can just coordinate later on. Thank you. Thank you again, Madam Chair. And thank you to everyone who has taken the time to provide testimony on the Baby ALEXYA Law Reform Act of 2025. The intent of this bill is to strengthen Guam's assisted outpatient treatment framework so that people experiencing psychiatric crisis can receive care earlier in a way that protects both public safety and individual rights. It shows that we're committed to building a system that responds with compassion and effectiveness. At the same time, the testimonies we heard today makes clear that there are challenges we must address before moving forward. From the clinical perspective, Guam Behavioral Health has reminded us that AOT must remain rooted in medical judgment. Expanded petitioning authority should never be used for convenience or punishment, but only when a qualified mental health professional determines is appropriate. Patients' rights must be protected as well, and the process must stay aligned with the original spirit of Baby ALEXYA law. From the judiciary perspective, the need for strong due process protection was emphasized. We heard the list of concerns about who should we allow to petition, the importance of training and oversight, clearly noticed requirements, guaranteed access to counsel, and the need to define standards of proof. All of these safeguards are essential to ensure that AOT remains a medical safeguard and not a criminal mechanism. Taken together, these perspectives show us the path forward. The bill's intent is sound, but it must be refined to balance clinical safeguards with judicial protections. So balance is really needed for our community. Our goal is to create a framework that truly reflects recovery-oriented care in the least restrictive setting, while also ensuring fairness, accountability, and respect for individual rights. So by working together, the judiciary and behavioral health professionals, policymakers, and the community, we can arrive at a clear solution that captures the true intent of the Baby ALEXYA law. We can strengthen Guam's mental health system, protect our people, and provide vulnerable individuals with the care and the dignity that they deserve. I look forward to continuing work on this important measure. Thank you so much once again. Thank you, Madam Chair.
Thank you, Senator Calvo, and thank you to members of the public who came here to testify on Bill 219, as well as those who were here previously to provide testimony on the appointment of Dr. Annie Bordallo. The time is now 10:37. This public hearing and confirmation hearing with the Committee on Health and Veterans Affairs is adjourned. Sizo Esmasi.